Welcome to Raos Academy, Hyderabad Branch. I'm Swetha. Today I'm here to teach prelims PYQs. Firstly, today's topic is with regarding to emergency provisions. So the first one is, which of the following are not necessarily the consequences of the proclamation of president's rule in a state? Firstly, let's have a brief background about president's rule. Whereas the term president's rule is also known as the state's emergency, which is also known as the constitutional emergency. Whereas this kind of president's rule is usually imposed in a particular state whenever that particular state is going against to a constitutional provisions or the constitutional machinery, then in that particular state, this kind of president's rule will be imposed. So when who will impose this kind of president's rule? It is the president will going to impose. That means the president will going to proclaim this kind of president's rule in a particular state, especially if the governor of that particular state will advise the president in order to impose the president's rule in state, or otherwise the president he himself will impose the president's rule on a particular state. So what are the implications of this president's rule on the different organs of a particular state? So different organs of a particular state includes the legislature and again the executive. Here the term legislature includes the legislative assembly as well as that of the legislative council if a particular state consists of a legislative council, and again the executive. This executive consists of the council of ministers, which is headed by the chief minister. So the implication of this particular president's rule on the legislature of that particular state include that this particular legislature will be get either dissolved or will completely get under control of the parliament. Whereas if you see its implication on the executive, the president's rule implication on the executive, it will lead to the executive, that is the council of ministers, which is headed by the chief minister, will be dismissed. That means completely removed. So in this brief background, let's solve these statements, which includes the dissolution of the state legislative assembly. As I told you before, the implication of the president's rule on the legislature is it is either gets completely dissolved or will come under that of parliament's control. So here it is directly given that it will lead to the dissolution of the state legislative assembly. That means the state legislative assembly is nothing but the legislature. So it is a correct statement. So as the first statement is the correct statement, let's strike this option, followed by it leads to the removal of council of ministers in the state. As I told you before, the term council of ministers will refer to the executive, whereas the implication of this president's rule on executive is that is the council of ministers, which is headed by the chief minister, they will be completely dismissed. The other term to this is they will be completely removed. So here it mentioned that the implication of this president rule is removal of this council of ministers in the state. So this is also a correct statement. So there is a possibility of option A and again option D. So let's strike this B option. So among these two options, let's find the correct statement. Here the dissolution of the local bodies. There is no such kind of particular mention that whether the local bodies, that is the Panchayati Raj institutions as well as that of the municipal bodies, will be get dissolved. There is no such kind of provision at all. So there is no such kind of thing. So these only 1 and 2 are the correct statements. So the option is A. Followed by, if the President of India exercises his powers as provided under the Article 356 of the Constitution of a particular state, then the options are the Assembly of the state is automatically dissolved. As I initially told that this Article 356, this Article 356 implies the president's rule. Firstly, in order to solve this statement, you have to know what does this particular article will refer to. Whereas this particular Article 356 refer to the imposition of president's rule in a particular state. So as I before told you, regarding the different implications of this president's rule on the legislature as well as that of the executive. So here it has given that the assembly of the state is automatically dissolved. Here the assembly of the state referred to legislature. So the assembly of the state is automatically dissolved. There is no such kind of thing. It will going to automatically dissolved. whereas the implication on the legislature includes it either dissolved or the legislature will be completely come under the parliament. So there is no such kind of, if there is an imposition of parliament, that means if there is an imposition of president rule, and there will be going to be a complete dissolution of the legislative assembly. So it is an incorrect statement, followed by the powers of the legislature of that state shall be exercised by or under the authority of the parliament. As I told you before, the implication of the president's rule on the legislature, that means it is either get dissolved or it will entirely comes under that of parliament. So here it clearly refers that the parliament will going to make the different legislations, as well as that of the budget will be released by that of the parliament itself. So here it mentioned that the powers of the legislature means this particular legislation of that particular state shall be exercised by or under the control of the authority of the parliament. So it is a correct statement. So let's read the remaining also. The Article 19 is suspended in that state. There is no such kind that Article 19 is going to get suspended. There are three different kinds of emergencies are present. One being the national emergency, the other being the state emergency or the parliament or the president's rule, and the other one being the financial emergency. So here the Article 19, that means it referred to that of freedom rights. They will going to get suspended only during the national emergency, but not during the state emergency. So it is going to be an incorrect statement. Then followed by the president can make laws relating to the state. As I initially itself told that under the president's rule, the parliament will going to make legislations for a particular state. So here it mentioned the president. It's not the president, it is actually the parliament which is going to make the laws with regarding to different states. So here the only B is the correct statement. So you get to know the different analysis of all these different statements. Followed by, consider the following statements in respect of financial emergency under the Article 360 of the Constitution of India. So here itself they have directly given the Article 360 referred to that of financial emergency. So here the proclamation of financial emergency is issued shall cease to operation at the expiration of 2 months unless before the expiration of that period it has been approved by the resolutions of the both houses of the parliament. So before going to it, let me give you a brief background. So firstly, this financial emergency. So whenever this financial emergency, there is a notice has been given in any one of the houses in order to impose the financial emergency, then it will going to given with a 2 months time period. For example, this is the time period during which the financial emergency issuance has been given, the notice has been given in one of the houses of the parliament. Then the parliament will be given with the 2 months time period in order to approve this financial emergency before the declaration of this financial emergency. So if in case the parliament fails to approve or give any response to this financial emergency within these 2 months, if they do not give any response within these 2 months, then this financial emergency notice will going to get dissolved. So here, that's what here it's mentioned, that a proclamation of financial emergency issued shall cease to operate at the expiration of the 2 months. Because if within the 2 months they have to take any action, but if they do not take any action within the 2 months, this financial emergency is going to get dissolved automatically. So that's what the first statement. Then followed by the unless before the expiration of the time period, it has been approved by the resolutions of both the houses. So it's a correct statement. Followed by, if any proclamation of the financial emergency is in operation, it is competent for the President of India to issue directions for the reduction of the salaries and the allowances of any class of persons serving in connection with the affairs of the Union, but excluding the judges of Supreme Court and High Court. Usually, this financial emergency is usually imposed whenever there is a credit stability or the financial instability has been observed in India. So in order to overcome this instability, the President of India will issue directions in order to reduce the salaries of different central government officers as well as the state government officers, which also include the different judges of Supreme Courts as well as that of High Courts. But here it has given that excluding the judges of Supreme Court and High Court. So it is going to be an incorrect statement, because the President of India will going to give directions during the financial emergency in order to reduce the salaries of judges of Supreme Court and High Court as well. But here it mentioned without exclude, they here in this particular statement they excluded the Supreme Court and High Court judges. So it is going to be an incorrect statement. So the option is only A. A is the correct statement. Followed by, which one of the following articles of the Indian Constitution provides that it shall be the duty of the Union to protect every state against the external aggression and the internal disturbance? So it is a direct reference of an article, which is the Article 355. This Article 355, which directly refers that it is the responsibility of Union in order to protect the state from the war or the external with regarding to the war and any external aggression and again the internal disturbances. So here the answer is D, that is the Article 355. Followed by, with regarding a concept called the funds with the Government of India. There are different kinds of funds with regarding to Government of India. One being the Consolidated Fund of India, followed by Public Accounts of India, followed by Contingency Fund of India. Whereas the Article 266 will refer to Consolidated Fund of India, whereas at the same time the Article 266 also referred to Public Accounts of India. Then followed by this Contingency Fund of India is referred under the Article 267. So firstly, this Consolidated Fund of India is nothing but whatever the revenues, that is in terms of the taxes and the loans taken by the Union government, and whatever the different sources of the revenues that have been received by the Union government will get into a particular account, which is called the Consolidated Fund of India. So in order to take the amount for the utilization of different schemes from this particular Consolidated Fund of India, there must be a particular law has to be passed in a parliament, which is called the Appropriation Act. So this Appropriation Act is nothing but it is the authorization, that means taking the permission from the legislation in order to take the money from the Consolidated Fund of India, followed by this Public Account of India. So here in this Public Account of India, the different revenues and the money comes into this particular account includes the PF, that is the Provident Fund, and again the different defense services deposits, ministers deposits, as well as the different departments deposits. This particular Public Act, this particular fund will be directly under the control of Central Government of India. So in order to take the money from this particular account, that doesn't require any particular legislation. It is completely operational under the executive, that is the Union government. Then followed by the Contingency Fund of India, whereas the different subjects which has been included in this Contingency Fund of India have been brought by the through a law by the Parliament. Whereas this Contingency Fund of India, whereas the amount from this particular Contingency Fund of India will be taken in order to fulfill the different unforeseen changes or different unforeseen situations. And also this particular Contingency Fund of India will be completely under control of, that is under operational of executive, that is the Union government. So let's see the statements. The authorization, here the term authorization is nothing but the permission or the consent. So here the authorization for the withdrawal of funds from the Consolidated Fund of India must come from, it is the Parliament of India. As I told you before, that is the who will give the authorization, that means who will give the consent to use the money from this Consolidated Fund of India, that is the Parliament, through passing an act which is called the Appropriation Act. That means through this Appropriation Act, Parliament is giving the permission to take money from the Consolidated Fund of India. So the option is B. Followed by, all revenues received by the Union government by way of taxes and other receipts for the conduct of government businesses are credited to which account? As I told you before itself, the different revenues that the Consolidated Fund of India will going to get include the loans, taxes, and the different sources of the revenues. So here it has directly mentioned that about the different taxes and the other receipts for the government of India. It is the Consolidated Fund of India, which is a direct static question. Followed by another concept which is called the systems of government. There are different systems of government, and the most prominent two systems of government include the presidential system of government and again the parliamentary system of government. Whereas India has adopted the parliamentary system of government, and India has borrowed this particular system of government from the UK. So here the question is, consider the following statements. A constitutional government is one which places effective restrictions on the individual liberty in the interest of the state authority. First and foremost, here the constitutional government is nothing but which follows the constitutionalism. That means which keeps limitations. That means it keeps the limitations on the power of different organs of the government. That means it keeps the limitations on the legislature, executive, as well as that of the judiciary. Here the term limitations includes the different subjects, one being that of separation of powers. Here the separation of power is nothing but the main emphasis of this separation of power is in order to not to let to keep this entire power in only one hand, so that we separate the entire power into three organs that include the legislative, executive, and judiciary. So, and also the other limitations that constitution is going to keep on the government include checks and balances. So here the each organ will keep checks on the other organ. So in that way, the constitutionalism includes the constitutional government includes the imposing the limitations on the government, but not the imposition of the limitations on the individual's liberty. So if we closely observe the different statements, this a constitutional government is one which places effective restrictions on the individual liberty in the interests of the state authority. As I told you before, this constitutionalism as well as the constitutional government will keep limitations on the government of the state but not on the individual's liberty. So first one is an incorrect statement. So let's strike the A option and again the C option, followed by the places effective. This constitutional government places effective restrictions on the authority of the state in the interest of the individual liberty. So this completely refer to that of this constitutional government or the constitutionalism, which keeps limitations on the authority of the state but not on the individual's liberty. So second one is an correct statement. So B is a correct statement. Followed by there is a parliamentary system of government in India because the Lok Sabha is directly elected by the people, followed by the parliament can amend the constitution, followed by the Rajya Sabha cannot be dissolved, and finally the council of ministers is responsible to the Lok Sabha. First and foremost, this parliamentary system and the main foundation stone of this parliamentary system is that council of ministers headed by the prime ministers has to be collectively responsible to the Lok Sabha. So that's what which refer to that executive is collectively responsible to that of legislature. So here, in order to fulfill that particular provision of the parliamentary system of government, it is the final D statement that which talks about the council of ministers is responsible to the Lok Sabha. Here the council of ministers refer to executive, whereas the Lok Sabha refer to legislature. So here the executive is responsible to legislature, which also refer to this executive is accountable to legislature. So option D is the correct statement. Followed by democracy's superior virtue lies in the fact that it calls into activity. So among these statements, so before getting into it, let's see what does the term democracy refer to and what does this term democracy refer to. Here this democracy is derived from the two terms which includes the demos and kratia. So here the term demos referred to people, whereas the term kratia referred to ruling or power. That means the entirely this democracy referred to rule of people or the power is in the hands of the people. So in that context, let's read the statements. It includes the intelligence and the character of the ordinary men and women. That's what this democracy is actually referred to. Because this democracy referred to the rule of the people. That means people will going to elect in order to represent them in the Lok Sabha as well as in different legislative assemblies. So, and also people will going to make decisions in different policies itself. So here, among the statements, the first one is the intelligence and the character of the ordinary man and the woman, followed by the methods for strengthening the executive leadership, followed by a superior individual with dynamism and vision, followed by a band of dedicated party workers. So among the four statements, and the most appropriate statements which refer to the virtue of the democracy include is the first statement, which directly gives emphasizes that ordinary men and women will take a greater part, they will going to take a greater part in the decision making, which that's what we refer to rule of people or the people's rule. That's what referred to democracy. So answer option A is the correct statement. Followed by a parliamentary system of government is one in which all political parties in the parliament are represented in the government, followed by the government is responsible to the parliament and can be removed by it. Then followed by the government is elected by the people and can be removed by them. Followed by the government is chosen by the parliament but cannot be removed by it before the completion of the fixed term. As I before itself told you, about this parliamentary system of government. This parliamentary system of government is a type of government, and the foundation stone of this type of government includes that the executive is completely responsible to that of legislature. That's what here the B statement referred to. Here the government referred to executive. This executive is responsible to that of legislature. Here the parliament referred to legislature, and this parliament can be removed by it. So that means here the government can be removed by parliament. Here after and it is the government can be removed by the parliament. So how the government can be removed by the parliament? Through no confidence motion. So in that way, that's how the parliamentary system of government works, through a foundational stone which is called that executive is collectively responsible to legislature. So option B is the correct statement. Followed by a constitutional government by definition is. So among the, before going into different statements, let's have a brief background of what this constitutional government is actually talking about. So here the constitutional government or the constitutionalism will refer to the limitations of power on the different organs of the government. So here the limitations includes the different limitations. One being the separation of powers. Here the separation of powers is nothing but that is dividing the entire power among the different branches of the government. That is the legislature, executive, as well as that of the judiciary. So these are the three different governments of the three different organs of the government. So that why we have made this separation of powers, because the main aim of this constitutional government is not to keep the entire power in only one hand, so that we separated the entire power among the three different organs. Then followed by the other limitation is through providing checks and balances. So through that, these three organs will maintain the checks and balances on each other. Then followed by that of judicial review. So the judiciary, that means that is the courts will going to interpret whether the laws, that means the legislations which were made by the parliament, they are either constitutional or unconstitutional in nature. So in that way, the constitutional government includes the limitation of power that or limited government. And here the term limited government involves the separation of powers, checks and balances, and again the judicial review. So among these four statements, it is the limited government which mainly refer to constitutional government. Followed by, and again, this question is repeated again and again for about 5 consecutive years. Here again, it has given that the constitutional government means, it again mentioned that among the options, it is a representative government of a nation with federal structure, followed by a government whose head enjoys the nominal powers, and the government whose head enjoys the real powers, and the government which is limited by the terms of the constitution. That's what the main emphasis of the constitutional government, as I mentioned before, because this constitutional government will provide the limited power to government. So option D is the correct statement. Followed by, we adopted the parliamentary democracy based on the British model. But how does our model differ from the model? How does our model differ from the British model? So in this context, let me tell you the difference between the UK government and again the Indian government, though both the governments are following the parliamentary system of government. And what are the main differences between the UK government and the India government, which are greatly different from each other? Firstly, in terms of the parliamentary sovereignty or the parliamentary supremacy, we will observe that parliamentary supremacy in case of UK, and we will observe in India constitutional supremacy. What is this terms parliamentary supremacy and again the constitutional supremacy referred to? Here the parliament is the prime one. That means that the parliament is the supreme, or it is the supreme law of land in case of UK. Whereas in case of the India, it is the constitution. Constitution is the supreme, and the constitution is above all. That means the constitution is above the parliament, judiciary, as well as that of the executive. So in case of the UK, the supreme power lies in the hands of the parliament, whereas in case of the India, the supreme power lies in the hands of constitution. So if we see the statements as regards the legislation, the British Parliament is supreme or sovereign. As I told you before, the British government follows the parliamentary sovereignty, or the parliament is the supreme in nature. So first one is the correct one. But in India, the power of parliament to legislate is limited. Yes, it is a correct one, because as I told you before, we are following the constitutional government where the constitution is supreme. So the first one is a correct statement. So let's cross the B and D options. Followed by, in India, matters related to the constitutionality of the amendments of an act of the parliament are referred to the constitutional bench by the Supreme Court. So it is a completely a correct statement, which is a direct static question, that whatever the amendments that the parliament will come up with, these amendments will go to that of the constitutional bench of the Supreme Court in order to interpret whether these amendment acts are in law or they are aligned with that of constitution or not. That means either they are following the constitution or not. So second one is a correct statement. So answer is the both 1 and 2. Followed by, consider the following statements. The Advocate General of State in India is appointed by the President of India upon the recommendations of the Governor of the concerned state. Firstly, here the term Advocate General of the state. Here the Advocate General is referred to the most important and the top law officer of a particular state. In the same way, at the union level, it is the Attorney General of India who is the top law officer of the entire country, whereas at the state level, the top law officer is the Advocate General of India. So here they are talking about the top law officer of the state. That is, the Advocate General of the state in India is appointed by the President of India. It's not the President of India, it is the Governor of India who is going to appoint this Advocate General of India, Advocate General of State. Whereas at the union level, this Attorney General of India will going to be appointed by the President, whereas at the state level, the Advocate General of State will be going to be appointed by the Governor. So here it is not the President, it is the Governor. So the first one is an incorrect statement. So let's cross these two options. Followed by, as provided in the Civil Procedure Code, High Courts have the original, appellate and advisory jurisdictions at the state level. First of all, it is not the Civil Procedure Code. It is actually the Constitution itself gives powers to the High Court in terms of having the original, appellate, and again the some of the advisory jurisdictions at the state level. So both of them are the incorrect statements. So the answer is neither 1 nor 2. followed by consider the following statements. The Central Administrative Tribunal was set up during the Prime Ministership of Lal Bahadur Shastri. Firstly, let me give you a brief background of this Central Administrative Tribunal. So initially, we have a particular legislation which is called the Administrative Tribunal Act 1985. Under this particular Act of Administrative Tribunal Act of 1985, there is a particular tribunal that has been constituted which is called the Central Administrative Tribunal in 1985. This Central Administrative Tribunal is nothing but it is a quasi-judicial in nature, or we can say it is a quasi-judicial body, and the members of this particular Central Administrative Tribunal include the judges and also different important officials or the different government officials from the center as well as that of the state governments. And what is the main aim of this particular tribunal is in order to redress the different grievances. That means in order to redress the different grievances of the different public employees in their administrative matters. So in order to overcome these problems in administrative matters, this particular Central Administrative Tribunal has been established. Whereas, as I told you, the members of this Central Administrative Tribunal includes the judicial members and also the higher officials from the center as well as that of the state. And these members of the Central Administrative Tribunal will be appointed by the President of India. So this is the brief background of the Central Administrative Tribunal. So now let's understand the statements. Here the Central Administrative Tribunal was set up during the Prime Ministership of Lal Bahadur Shastri. First of all, this Lal Bahadur Shastri reign has been ranged from 1964 to 66. But whereas the Central Administrative Tribunal has been established during the 1985, during the time of 1985, the Indian Prime Minister is the Rajiv Gandhi. So it is, first one is an incorrect statement, followed by the members of the Central Administrative Tribunal are drawn from both judicial as well as that of administrative streams. As I told you, the members of the CAT were taken from the judiciary as well as that of the administrative fields. Here the administrative fields refer to that of the important and the top officials from the state as well as that of the central government. So second one is a correct statement, first one is an incorrect one. So the option B is the correct statement. Followed by with reference to Indian Parliament, which one of the following are not correct? That means it is talking about the incorrect statement. Firstly, here the appropriation bill must be passed by both the houses of the Parliament before it can be enacted into law. It is an incorrect statement. This is because this appropriation bill is nothing but it is a money bill. So here it mentioned that this particular kind of money bill must be passed by both the houses of the Parliament. This kind of money bill must be passed by that of Lok Sabha. There is no such kind of must or the mandatory provision for the Rajya Sabha. So it is going to be an incorrect statement because the Rajya Sabha can give recommendations, but it is not the mandatory that Rajya Sabha to reject this particular money bill. So A is an incorrect statement. Let's see the remaining options also. No money shall be withdrawn from the Consolidated Fund of India except under the appropriation made by the Appropriation Act. It is a correct statement. Here the appropriation is nothing but it refers to that of permission or the consent from the Parliament in order to draw money from the Consolidated Fund of India. So second, B is a correct statement, followed by a finance bill is required for proposing new taxes, but no additional bill is required for making changes in the rates of taxes which are already under operation. So it is also a correct statement. This is because the main aim of this finance bill is in order to bring amendments or the changes with regarding to that of taxes. So it is a correct statement, followed by no money bill can be introduced except on the recommendation of the President of India. So it is definitely a correct statement. So usually during which time or during for which bills we are going to take the consent or the permission of the President before the introduction of a particular bill, it is the only money bill. So for the introduction of the money bill, it is very important in order to take the permission from the President of India before its introduction in the Lok Sabha. So the incorrect statement is A. Followed by the next topic is about the President. So according to the Constitution of India, it is the duty of the President of India to cause to be laid before the Parliament. Which of the following? The President of India is going to lay different reports before the Parliament. Here, that's what it has mentioned. Which kind of these reports will be submitted by the President in front of the Parliament? Here, firstly, the recommendation of the Union Finance Commission. So yes, it is a very important one. Here, the Union Finance Commission, it is a constitutional body. So the report of this particular constitutional body will be laid by the President in front of the Parliament. So first one is a correct one. So as you do not see the first one in the B option, let's strike this. Followed by report of the Public Accounts Committee. This Public Accounts Committee is one of the committees of the Parliament. So there is no requirement that President has to take the report from the Public Accounts Committee in order to submit it directly in front of the Parliament. It is an incorrect one because this Public Accounts Committee is directly part of the Parliament itself. So the second one is a incorrect one. So let's eliminate the D option as well. Followed by the report of the Comptroller and Auditor General. It is again a constitutional body. So the main theme is there are different kinds of constitutional bodies like UPSC, Election Commission of India, CAG, that is the Comptroller General of India, and again there are different kinds of constitutional bodies. So all these kinds of constitutional bodies will make reports and they submit these reports to President of India, and then President of India will lay these reports in front of the Parliament. It is not these constitutional bodies will going to directly give their reports to Parliament. Then followed by the report of National Commission for the Scheduled Castes. It is also again a constitutional body. As I told you before, these constitutional bodies will going to give their reports to President, and President is going to submit them in front of the Parliament. So the answer is C, that is 1, 3 and 4. Followed by consider the following statements. The President shall make rules for more convenient transaction of the business of the Government of India and for the allocation among the ministers of the said business. It is a true statement because it is the President of India who is going to make different rules or the amend rules in order to make the business of the house in a better way, in an amicable and convenient way. So first one is a correct statement. So let's cross the B and D. Followed by all executive actions of the Government of India shall be expressed to be taken in the name of Prime Minister. It is an incorrect statement. All the executive actions of the Government of India will be taken in the name of President of India. So answer is A. Only the first statement is a correct one. Followed by consider the following statements. The executive power of the Union of India is vested in the Prime Minister. First and foremost, here the executive power of the Union is mainly rests in the hands of President of India. So first one is an incorrect one. Followed by the Prime Minister is the ex officio chairman of the Civil Services Board. It is not the Prime Minister. It is the Cabinet Secretary. Cabinet Secretary is the ex officio chairman of the Civil Services Board. So the option 1 and 2 both are incorrect. Answer is neither 1 nor 2. Followed by, with reference to the election of the President of India, consider the following statements. Here it has mentioned about the value of the votes of MLA and again the value of votes of MP. So let's get to know about the different formulas of value of MLA vote and again the value of MP vote. Firstly, the value of MLA vote formula is, it is the entire population of that particular state to that of the total number of elected legislative seats present in the Legislative Assembly. Followed by the formula of MP vote includes it is the sum of total value of all the MLA votes of all the states to that of the total number of elected seats of MPs in the parliament. So in this context, let's see on the basis of these formulas, these statements. The value of the vote of each MLA varies from state to state. Yes, it's a correct one because from state to state, the population of the state varies. So as the population of the state varies, the value of the vote of MLA varies from one particular state to another particular state. So first one is a correct one, followed by the value of the vote of MPs of the Lok Sabha is more than that of the value of the MPs of Rajya Sabha. It is an incorrect one because the value of vote of MPs of both Lok Sabha and Rajya Sabha is same, which is based on that of this particular formula. So the value of MPs of Lok Sabha and Rajya Sabha is same, but the value of vote of MLAs differ from one particular state to another particular state because of differing in its state's population. So the second one is an incorrect statement. So answer is only one. Followed by, consider the following statements in respect of election to the President of India. So firstly, before getting into the election of the President of India, so let's understand about the Electoral College of President of India. So here, what does this term Electoral College refer to? Here the Electoral College refer to those members who has the eligibility to vote in the presidential elections. So here the Electoral College of the President of India includes the elected members of the parliament, because usually in both Lok Sabha and Rajya Sabha there are some of the nominated members, but here the people who are eligible to vote in the president election include only the elected members of the parliament and again the elected members of the legislative assemblies of all the states and again the union territories of Puducherry and again New Delhi. So here firstly at the union level, the elected members of the Lok Sabha and Rajya Sabha, and at the state level only the elected members of only legislative assembly. It doesn't include the legislative councils. Here includes the elected members of the legislative assemblies of all the states and also include the union territories of Puducherry and the New Delhi. So let's read the statements now. Here the members nominated to either House of the Parliament or the legislative assemblies of the states are also eligible to be included in the Electoral College. Here before only I told you that there are no such kind of nominated members will be eligible to vote in the presidential elections. So here it has given that nominated members also have the right to vote in the presidential elections. So first one is an incorrect one, followed by the higher the number of elective assembly seats, higher is the value of the vote of each MLA of the state. So it is based on the MLA vote value. So firstly, as I told you before, value of vote of an MLA. It has a formula which includes the total population of that particular state to that of total number of elected seats of that particular state. So that is the value of vote of a particular MLA, that is the ratio of the total population of that particular state to that of the total number of elected seats of legislative assembly. So as he here given that higher the number of elected assembly seats, higher is the value of the vote of MLA. So it has given that higher in the value of this total number of elected seats will lead to increase in the value of the MLA. It is not the correct one, right? If the increase in the value of the denominator, it will lead to decrease in the entire value. So it is an incorrect statement. Followed by the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. So the answer to this will be given based on that of population basis. That means the population of Madhya Pradesh is lesser than that of the Kerala. But here it has given that the vote of each MLA value of Madhya Pradesh is greater than that of the Kerala. But it is lesser because Madhya Pradesh is having the lesser population than that of the Kerala. So it is an incorrect statement. Followed by the value of vote of each MLA of Puducherry is higher than that of the Arunachal Pradesh, because the ratio of the total population of the total number of elected seats in the Puducherry is greater than as compared to that of Arunachal Pradesh. It is also incorrect statement. It is because the Arunachal Pradesh itself has a greater population than that of the Puducherry, but it has given that the Puducherry has the greater population than that of Arunachal Pradesh. So here the only one statement is a correct one. That is that one, followed by consider the following statements. If the election of the President of India is declared void, that means the election of the President of India is nullified, then by the Supreme Court of India, all the acts done by him in the performance of the duties of his office of the President before the date of decision becomes invalid. There is no such thing. For example, here is the President of India and he made some kinds of legislations, that is the acts or the bills. So but after certain time period, it has been observed that the Supreme Court has nullified this presidential elections and impeached this particular president. But before the impeachment, whatever the laws and the acts made by this particular president will be considered valid but not invalid. But it has been given that all the legislations which are made before the impeachment of the president will be invalid. It is an incorrect statement. So the elections for the post of the President of India can be postponed by the ground that some legislative assemblies have been dissolved and elections are yet to take place. The president elections do not going to wait for whether some of the states legislative assemblies are get dissolved, or the president elections do not wait for the fresh elections of the legislative assemblies of the different states. So it is an incorrect statement. Followed by, when a bill is presented to the President of India, the Constitution prescribes time limits within which he has to declare his assent. It is an incorrect statement because the President of India has a pocket veto. There are different kinds of vetoes for the President of India. So one of them being that of the pocket veto. Here the term pocket veto referred to whenever a bill has been presented to the President of India, it is up to the President whether to give assent immediately or to take as long as time that he wants. There is no such kind of time limit that President has to give his assent within a particular time. That's what we call it as the pocket veto. So the answer is none. All are the incorrect statements. Followed by, under which article of the Indian Constitution did the President give his assent to the ordinance on the electoral reforms when it was sent back to him by the Union Cabinet without making any changes? So usually here it is asking about the article with referred to the ordinance. It is the article 123. Here this ordinance is nothing but it is the legislation which is going to made by the President of India during an emergency or unforeseen situations, and the President is going to make this kind of ordinance legislations whenever the Parliament is not in session. So here the article which referred to that of ordinance is Article 123. Followed by, consider the following statements. In the Electoral College for the presidential election in India, the value of vote of an elected member of the Legislative Assembly, here it has directly given the value of vote of MLA and again the value of vote of an MP. Here it has directly given the formulas of MLA vote value and again the MP vote value. Here the value of vote of an elected member of the Legislative Assembly, that means MLA vote value is the ratio of state population to that of number of elected MLAs of that state into 100. It is a correct statement. Followed by the value of the vote of an elected member of parliament. Here it is talking about the value of vote of an MP, and the formula is total value of the votes of all the elected MLAs to that of total number of elected MPs. So both of them are the correct statements. Both are the correct formulas. Followed by, which one of the following is a part of electoral college for the president but not the forum for his impeachment? So let's write the electoral college of the president and the people who has the eligibility to participate in the impeachment process of the president. So here, for example, we take here, this is the president and this is the electoral college. That means this include the people who has the eligibility to vote in the presidential elections. Whereas the term impeachment is nothing but it talks about the removal of the president of India. So here this electoral college includes the elected members of parliament, followed by the elected members of legislative assemblies. Whereas here the impeachment process includes the elected members of the parliament as well as that of nominated members of the parliament as well. But it doesn't include the elected members of the legislative assembly. So here it has asked about the difference between these two positions. So here it is asked, who of the following will be a part of the electoral college for the president, but not for the impeachment process. So here it is the legislative assemblies. These are the legislative assemblies. That means the elected members of the legislative assemblies who are a part of the electoral college, but these are not part of this impeachment process. So this is all about the president. Followed by the next concept is the vice president. Consider the following statements. The chairman and the deputy chairman of the Rajya Sabha are not the members of the House. Firstly, if we see, this is the Rajya Sabha, which includes the chairman and again the deputy chairman. Here the chairman of Rajya Sabha, we call it as the vice president. And this vice president is the ex officio member of the Rajya Sabha. Whereas this deputy chairman is the directly elected from the among the members of the Rajya Sabha. Whereas it has here given that the chairman and again the deputy chairman of the Rajya Sabha are not the members of that particular house. Whereas it is correct up to for the chairman, but it is incorrect for the deputy chairman, because deputy chairman is one of the member of the Rajya Sabha, whereas that of chairman is an ex officio person. So one is an incorrect statement. Followed by, while the nominated members of the two houses of the parliament have no voting right in the presiding election, in the presidential elections, they have the right to vote in the election of the vice president. So here it has talking about the nominated members of the two houses. It has mentioned that these nominated members of the two houses, that is the Lok Sabha and Rajya Sabha, have no voting right in the presidential election, which is a correct statement. Whereas these particular nominated members, they have the right in the election of the vice president. It is a correct one. So again, let's compare the electoral college of the president of India and again the vice president of India. So here the electoral college is, it refers to who has the eligibility to vote in the president elections, who has the eligibility to vote in the vice president elections. So here in president, it includes the elected members of the parliament, but this does includes the nominated members of the parliament. Whereas in case of the vice president elections, the electoral college includes the entire members, that is all members of the parliament. This includes both the elected members as well as that of the nominated members. That's what it has given, that the nominated members of the two houses of the parliament have the no voting right in the presidential elections, which is a correct statement. Whereas these nominated members of the parliament have the right to vote in the vice president elections. They do not have the right to vote in the presidential elections, whereas they have the right to vote in the vice presidential elections. So second one is a correct statement. So option B is the correct one. Followed by, who among the following have held the offices of the vice president of India? It is a very static question, that Muhammad Hidayatullah and again the Shankar Dayal Sharma, these are the two persons who held the positions of the vice president, whereas these two personalities did not attain the vice presidentship, but they became the presidents of India later. So here it has asked about the who have adorned the position of vice president of India. It is the only 1 and 4. That is option B is the correct statement. Followed by, the resolution for removing the vice president of India can be moved in. First of all, this vice president is nothing but the chairman of Rajya Sabha. Whereas the removal of this vice president or the chairman of Rajya Sabha can be done. That means the removal process for the vice president can be initiated only in the Rajya Sabha. So here it has given directly Rajya Sabha alone. It is a correct statement. Followed by the concept of Prime Minister. So here the Prime Minister of India at the time of his or her appointment need not necessarily be a member of one of the houses of the parliament, but must become a member of one of the houses within the 6 months. There is a kind of provision that either the Prime Minister or any minister of India who are not a member of both Lok Sabha as well as that of the Rajya Sabha. For example, let's take a person who is called the X, who is not a member of Lok Sabha as well as not a member of the Rajya Sabha. But this particular person can become the minister in the union government level. How this particular person who is not a member of both Lok Sabha and Rajya Sabha but can become the minister, whereas this particular person can become the minister who will be appointed by the President of India on the advice of the Prime Minister. Though he is not a member of Lok Sabha or the Rajya Sabha, this person, after getting appointed as the minister, has to become any member of either Lok Sabha or that of the Rajya Sabha. So any strange person who is not a member of Lok Sabha or Rajya Sabha can become the minister, and after becoming minister, he has to join as a member of either Lok Sabha or Rajya Sabha. This particular provision will apply to both the Prime Minister as well as that of the ministers of the union government as well as that of the state governments. So here the terms with regarding statements with regarding to Prime Minister include the Prime Minister need not necessarily be a member of one of the houses of the parliament, but must become a member of one of the houses within the 6 months. So it is a correct statement. Followed by need not necessarily be a member of one of the houses of the parliament, but must become a member of Lok Sabha. It is not mandatory that he has to become only the member of the Lok Sabha. There is an option that he can become the member of Lok Sabha or that of Rajya Sabha. So second one is incorrect statement. He must be a member of houses of the parliament, followed by he must be a member of the Lok Sabha. So option A is the correct statement. Consider the following statements. Jawaharlal Nehru was in his 4th time as the Prime Minister of India at the time of his death. So let's see the different reigning years of the Jawaharlal Nehru, which includes he reigned from 1947 to 1952, followed by 1952 to 1957, and again from 1957 to 1962, followed by 1962 to 64. So this is the first term, second term, third term, and again the fourth term. During the fourth term, he died. That is while ruling from 1962. Actually, he has to rule up to that of 1967, but he died in the year of 1964. That is at during which term? Fourth term. So it has mentioned that Jawaharlal Nehru was in his 4th term as the Prime Minister of India at the time of his death. It is a correct statement. Whereas the Jawaharlal Nehru represented Rai Bareli constituency as a member of the parliament. It is an incorrect statement. It is the Indira Gandhi who has represented this particular constituency at the parliament level. So second one is an incorrect statement. So let's cross this option. Followed by as we also know that first one is a correct statement. So let's strike this one because we already know that first is definitely a correct statement. So there is no need to consider this option. Followed by the first non-Congress Prime Minister of India assumed the office in the year of 1977. That means in the 1977 is the first year, that is after the emergency. It is during this particular year the first non-Congress government has been constituted. That is the Janata Party under the Prime Ministership of Morarji Desai. So it is again a correct statement. So answer is 1 and 3. Option D is the correct statement. Followed by if the Prime Minister of India belongs to the upper house of the Parliament, he will not be able to vote in his favor in the event of no confidence motion. Firstly, let me give you a brief background about with regarding to right to speak and again the right to vote. For example, this is the Prime Minister. This Prime Minister, for example, is a member of the upper house as per given in the statement, and the other house being that of the lower house. Now, this Prime Minister is a member of this upper house. So, whosoever is the member of that particular house has the right to vote in that particular house only. For example, Prime Minister is a member of the upper house. He has the right to vote only in the Rajya Sabha. He doesn't have the right to vote in the Rajya Sabha. But though he doesn't have the right to vote in the Lok Sabha, he has the right to speak. That means whosoever the member of either Lok Sabha or the Rajya Sabha, that particular member has the right to speak in any of the houses. But if a person who is particularly a member of a particular house, he has the right to vote only in that particular house, as it has given that Prime Minister is a member of the upper house. So he has the right to vote only in the Rajya Sabha, but he doesn't has the right to vote in the Lok Sabha. As he doesn't has the right to vote in the Lok Sabha, he can't vote for his no confidence motion. That's what it has given, that he will not be able to vote in his favor in the event of no confidence motion. This is because being a member of the Rajya Sabha, he cannot vote for a no confidence motion in the Lok Sabha. So it is a correct statement. Followed by he will not be able to speak on the budget in the lower house. He has the right to speak in the Lok Sabha. It is an incorrect one. Followed by he can make statements only in the upper house. It is an incorrect one. He can also make statements in the lower house as well. Followed by he wants to become a member of the lower house within 6 months after being sworn in. So there is no such kind of provision that he has to become the Lok Sabha member after being sworn in. The members, that means there are different members. That is for example, it is the Indira Gandhi, who is a member of the upper house, that is the Rajya Sabha, has become the Prime Minister of India. There is no such kind of mandatory provision that Prime Minister has to come from the Lok Sabha only. So here the option is only A. Followed by which one of the following statements about the duties of the Prime Minister is correct? He is free to choose his minister only from among the members of either house of the Parliament. He can choose his cabinet after consulting the President of India. Followed by he has the full discretion in the choice of the persons who are to serve as the ministers as the cabinet. Followed by Prime Minister has only limited power in the choice of his cabinet colleagues because of the discretionary powers vested with the President of India. Here, the brief background of this particular topic is the whosoever the different ministers or that of the cabinet ministers, that President is going to appoint these Prime Minister as well as that of the ministers. Whereas the President, after appointing the Prime Minister, President will appoint the different ministers on the advice and based on the discretionary powers of the Prime Minister. So it doesn't mean that Prime Minister will going to consult the President. Prime Minister has the full discretionary powers in terms of who is going to be a particular minister. So it is the option C, that Prime Minister has the full discretion in the choice of persons who will be going to serve as the ministers. Followed by, with reference to union government, consider the following statements. The ministries and the departments of the Government of India are created by the Prime Minister on the advice of the Cabinet Secretary. Here, it is again incorrect statement. It is the Prime Minister's full discretionary power. He do not going to take any advice from either from the Cabinet Minister nor from that of the President. So first one is an incorrect one. Followed by each of the ministers is assigned to a minister by the President of India on the advice of the Prime Minister. So it is a correct statement because the ministers will be appointed by the President on the advice of the Prime Minister. So second one is a correct statement. followed by, it is an assertion reason, which includes the Council of Ministers in the Union of India is collectively responsible to Lok Sabha and the Rajya Sabha, which is an incorrect statement because this particular statement is a direct foundational stone of parliamentary system of government. So according to this particular parliamentary system of government, the Council of Ministers, who will be headed by the Prime Minister, that means this particular part of the executive will going to be directly responsible or accountable to Lok Sabha only. It is not Rajya Sabha. So it has mentioned the Rajya Sabha also, it is an incorrect one. So without reading the reason, you can come to conclusion that as the assertion is a false statement, it is the only option which says the assertion is false. So without reading the reason, you can come to a correct answer. So if we see the reason, the members of both Lok Sabha as well as Rajya Sabha are eligible to be members of the union government. Yes, it is a correct statement. There are different kinds of finance ministers who have been appointed as a ministers from the Rajya Sabha. So it is a correct statement. So option D is the correct one. I think the lecture is informative.